This is webinar in regards to eviction protection after April 1st, 2022. And we are from Project Sentinel. To be exact, my name is Ahmad Raji. And so next slide.
It's not working, sorry.
Okay. My name is Ahmad Raji, 408, and the number and email is there for contacting me. And Allison is also contact information is provided there. You can see, please jot it down because you may need it in the near future. The next slide, Allison.
I just wanted to share that Project Sentinel is a nonprofit that serves many jurisdictions in the Bay Area with landlord-tenant counseling, education, mediation as one of our branches. And then another branch is for fair housing. If you feel that you're being discriminated against for some reason in regard to housing, whether it's being able to rent a place or the way you're being treated where you're renting, we have a fair housing department with lawyers that will help you with your case. And we also have a mortgage counseling unit that works with both homeowners who are having difficulties with their mortgage payments and foreclosure prevention, as well as new buyer education. So we offer many different services regarding mainly education, but also with the fair housing, some legal advice. So just call us if you have any issues with housing related needs.
Or visit our website at housing.org.
Even better, then you'll get a big full picture of what we do.
Yes. Okay, the agenda for today is a brief or actually an in-depth preview of AB 2179, eviction protection for the applicants, timeline of state COVID protection, other protections available local and county-wise, what to do if you receive a notice, application statuses, and alternative sources of assistance. And at the end, we will have a chance to answer your questions. Basically, AB 2179, if you want a full bill text, you can reach there. You can see the link there. AB 2179 continued AB 832 protection, and it continued till end of June this year, 2022, provided that the tenants have applied prior to March 31st. Landlords can evict for April, rent forward, and for any rent due from April 1st that is not covered by rental assistance. Other rules apply that we will discuss those as well. Okay, Allison, we have to go that way. Okay, as you can see, the timeline shows that AB 832 covered till the end of March, and AB 2179 came and extended it till end of June. As July starts, everything goes back to pre-pandemic situation. Individuals who applied for the state or local rent relief program and are awaiting payment or final decision are protected under AB 2179 and cannot be evicted for rent that accrued due to COVID prior to March 31st. Please pay attention. They cannot be evicted prior for prior death to March 31st, 22. Once final decision is reached, remaining unpaid rent can be pursued by a landlord in small claim court, but eviction cannot be done. Next
And
slide.
so just to be really clear, it's only for people who have an application in the system that has not been decided. A final decision is when you get approved or denied, or if you appeal, once the appeal is denied or approved, that's a final decision.
Thank you. Once again, we emphasize to the back that all renters must pay rent up April 1st, 2022. Failure to pay rent due to April 1st and beyond can result in eviction. Okay, Allison.
So what Raji was talking about is protections for people that have their application in and it has not been finalized yet. They don't have a final decision. However, there are other protections. If you still owe rent that was due between March 1st and August 31st of 2020, that's the very beginning of the pandemic, and you submitted a declaration of COVID-19 financial distress to your landlord, the landlord still may not be able to evict you for that unpaid rent. They can pursue payment in small claims court for that rent if it's unpaid. So if you didn't apply or your application was denied, you still have some protection from eviction for that unpaid rent, but you still owe it to your landlord. And if it's not paid, they can take you to small claims court. The declaration that you were supposed to submit confirms that you can't pay the full rent because of COVID-19. And if you've never sent that to your landlord, send it now and save a copy. It might help you be able to stave off eviction. We would advise legal advice. But I also wanted to note that if your household income, if a tenant's household income is at least $100,000 and is 130% of your area median income, you may need to provide additional documentation of your COVID-19 hardship. The link for the declaration is here. It's on the Housing is Key website. Raji, maybe, I don't know if you can put this in the chat, but I'm going to show you what it looks like. The declaration of COVID-19 related financial distress looked like this. It was a form. This only shows the questions. There's a place at the bottom to sign. And it said that you were unable to pay the rent or other financial obligations under the lease in full because of one or more of these 6 options. Loss of income caused by the pandemic, increased out-of-pocket expenses because of performing essential work, increased expenses related to health impacts. So if you actually had COVID and needed to pay for medical expenses, that would be included. Childcare responsibilities or elder care or helping sick or disabled family members related to the pandemic that limited your ability to earn because those folks were unable to go out into the community to get the care they need or have caregivers come in and you needed to do that and you couldn't work. That is a financial impact. Or if you had increased costs for childcare or attending to your elderly, disabled, or sick family members because you did have to work and you had to pay extra to have care for them, that's an increased cost. And then there are other circumstances that may have reduced your income or increased your expenses. If you have some reason that COVID-19 impacted you financially, then you are qualified to use this form to declare financial distress. And then you sign and date it. This form also relates to rent that was due between September 1st of 2020 and September 30th of 2021. For that whole year, if a tenant was unable to pay rent that was due, the landlord cannot evict a tenant for that any rent that was unpaid during that time frame if the tenant submitted that declaration. And if the tenant paid 25% of the rent that was due. through September 30th, between September 21st and September 30th. So that's two conditions that apply to this unpaid rent, both the declaration and having paid 25%. And a landlord, again, can pursue payment in small claims court for that other 75%, or whatever percent remains unpaid by the tenant. The declaration, as we saw before, requires the tenant to confirm they couldn't pay the full rent because of COVID-19. And if a tenant did not pay the 25% of that rent by September 30th, we suggest you talk to legal aid. You can find a list of legal aid, free legal advice organizations at lawhelpca.org, and contact them immediately to see if you might be able to pay back the rent now to save your home. You could also reach out to Project Sentinel and request mediation. We may be able to negotiate with your landlord if you have a way to, if you have some of the money and you can, if you can pay it, they may not evict you. It saves them from going to small claims court. So in case your income again is over, if the tenant income is over 100,000 and at least 130% of the county median income, you may need to provide the additional documentation of the COVID hardship.
I wanted to add, Allison, on www.lawhelpcalifornia.org. Please write it down. A lot of information and probably free assistance.
Well, it has links to, it has a listing by your location of other program of the different organizations providing free legal advice. That's what that lawhelpca.org link is for.
Okay.
All right. So then there was also the Tenant Protection Act of AB 1482. That predates the pandemic, not by very much. It came into force and then the pandemic happened and the new regulations about unpaid rent came into place. During that period, you could still be evicted if you were breaking your lease, but not for unpaid rent. So now, AB 1482 applies to, again, almost all rental units in California. There are several exceptions. It does not apply to single-family homes that are not owned by a corporation or investment company. So if you're in a single-family home, or if you're a private landlord, or you live in a home owned by a private landlord, AB 1482 does not apply. However, landlords are required to provide a notification to their tenant that they are not covered, and they cannot serve eviction papers or pay quit notices or other papers to their tenant until after the tenant has been notified that they are not covered by 1482, the unit's not covered. And that applies to these other kinds of units. Units that are covered by local rent control, that is more protective to the tenant than 1482. They are subject to those local ordinances, which are stronger than the state's protections, so they may cover these other kinds of units. Under the state law, units that were constructed in the last 15 years are not covered by the Tenant Protection Act. However, it's a rolling timeline, so every year it changes which units are included. If your unit is 14 years old this year, next year it's covered because it'll be 15 years old. Mobile homes are not covered. Duplexes where the owner was living in one half when the tenant moved in and continues to live there are not covered. And affordable housing that's under deed restriction or regulatory agreements or other kinds of agreements are not covered, and dorms are not covered under AB 1482. So it sounds like a lot that's not covered, but really most units in California are covered. So what 1482 did, it capped rent increases for most tenants in California. Landlords cannot raise the rent annually more than 5% plus inflation with a maximum of 10%. Unfortunately for tenants, inflation, the consumer price index, inflation is high this year, but that max of 10% applies. Landlords have to be careful that they are calculating correctly, that the 5% plus inflation is the maximum unless it's over 10%. And that is California-wide. It's not by your particular county. And the other portion of 1482 applies to eviction protections. So all units that are covered by 1482 are, the tenants are protected from eviction for everything except just cause. So if the owner plans to move in, and the owner needs to document that if they're not moving in, if they don't move in within a certain time frame, they can be sued. Also for substantial rehabilitation or remodel, or the intent to demolish the unit or withdraw the unit from the rental market. In all these cases, the landlord should be documenting everything to show that what they're saying, the cause of eviction, is true. And of course, if a tenant breaks the lease, including non-payment of rent now, if it's not covered under the other protections related to the pandemic, those always are just cause for eviction. If the lease is legal, you have to make sure, landlords, that your lease is not including wording that would give you an out, a back door to eviction, because that's not allowed. And I would recommend getting legal advice about that.
Immediately.
And the owner has to comply with, if the owner has to comply with any orders issued by the government or courts that require the tenant to leave, whether it's based on habitability or other issues, then, or if a local ordinance requires that the tenant leave, then the owner is allowed to evict a tenant. And we always say landlords should consult with an attorney to make sure they're complying with the law if you are intending to evict someone for any reason. In addition to those specific eviction protections, there are other tenant rights that landlords should be aware of. If a landlord participated in the Housing is Key program by submitting their own application, they cannot initiate eviction or late fees for rent payments that were covered under the program. That was agreed to in the contract that on the submission page of your application. So that needs to be complied with. Also, I just wanted to let landlords know that repeatedly asking for payment of pandemic-related debt while awaiting that final decision from Housing is Key could be considered harassment under the Civil Code and is prohibited. And then finally, landlords cannot retaliate against a tenant because they applied for rental assistance. It's both considered discrimination against source of income, which is protected, and it's also unlawful to evict or otherwise retaliate against an individual for asserting their rights under the Civil Code. So this page is primarily for tenants. Because there are so many different situations, we advise you to get legal advice when you get any kind of notice, 3-day notice, or any kind of notice or eviction papers. If you do get a court summons, you have 5 days to file your response. If you have a rental assistance application that's in the Housing is Key system, call the phone number here, 833-430-2122. That's the call center. You can also find it on their website. And actually, this is not the call center number, is it? I'm not sure.
2122 it is.
Yes, it is the call center. But you can tell them that you're being faced with eviction and ask them to prioritize your application. And there is an email address to send copies of your eviction papers as well. And you can contact us if you want help with that. But it's very important to call, let Housing is Key know, and see if they will speed up the application processing. Please file your papers with the court within 5 business days. And the Santa Clara County Superior Court has a self-help center. If you live in another county, you can look online to find out if your county has a similar program. I believe they do in San Mateo County and probably Alameda County as well. For Santa Clara County, they have in-person services from Monday to Friday, mostly in the mornings, goes till 1:30. Except Fridays, they close at noon. And they're down on First Street in San Jose at the Family Justice Center Courthouse. Or they provide remote assistance also Monday, Tuesday, and Thursday in the mornings through 1:30. And you can access that by going to www.scscourt.org and clicking Contact the Self-Help Center. There's also really helpful information on the court's website, the state website, courts.ca.gov/self-help-eviction.htm. But primarily, we want to say, don't move out without learning about your options. There are all these different protections in place. People often move out as soon as they get a notice. And what's important to do when you get a notice is follow up, get legal advice, file your response within 5 days. If we heard the other day that the Law Foundation of Silicon Valley, for example, and I believe Bay Area Legal Aid are both kind of getting swamped and may not be able to respond within 5 days. If you file papers within 5 days, you can go back and amend it at a later date. Don't wait. You need to get that response in 5 days, even if it's not complete. So that's 2 things we want you to take away from the seminar. If you are a tenant and you get any kind of legal notice, you want to respond within 5 days, get legal advice.
And another thing, Allison, you should say, emphasize the fact that pay your rent April forward.
Yeah, and we're going to talk a little bit more about that in a minute. But before we get to that, we wanted to give you some more information about your rental assistance applications. If you still have an application in the system, these are statuses that need your immediate attention.
Thank you, Allison. It was very good information I believe people can use. The statuses that we have noticed on the state site, Housing is Key, according to the importance we are listing here, please we stress that these statuses that you see on the screen are the ones that will need your immediate attention. If you are denied option B is almost no, it's the same as the status 14. Option B is a geographic representation, and I believe they had option C as well too. But if you are denied, they have to, for the first time, they have to provide you with a link for appealing, and don't wait for the denial to go through. Just reach out. We can assist you in appeal. So you have to move fast. If your application is in status 19 non-responsive, that is dangerous also, because they can move it to denial. I believe starting next week, they're gonna, all the applications, whether non-responsive or not, they're gonna move to denied and subject to appeal.
I just wanted, sorry, Raji, I wanted to mention, I think you skipped over that when application is denied, how much time does the tenant have or the landlord have to respond with an appeal?
I think at starting at May 15, it has been reduced to 15 days. And I have received an email from the LPN that is putting the process in perspective. I have not, starting next week.
Please
If,
forward that to me. Yeah, so it's really important if you get it denied that you appeal, but don't click on the link until you have your documents ready. I think maybe we should add a slide in here about what to do when you're denied, how to appeal, because they're saying don't upload the same documents you included before. The denial is based on the documents you provided. So you need to understand what their reason for denial was and what documents might satisfy for an appeal. If you need help with that, please reach out to us. We can sometimes get insight into the reasons for appeal that may not be clear. Sometimes it just says inconsistencies. We don't know what that means. How do we know what that means? What documents do you need to provide to clear that up? So we can sometimes reach out to Housing is Key and get more information, and make sure you have, sometimes the documents that submitted were blurry or were not in the right format. So, or they just weren't able to reach the landlord to get a ledger. So we need to know what the cause of the denial is and then provide the correct documentation in the appeal. It's a one-time link. So you want to make sure you have everything ready to go, but you only have a couple weeks to do that.
Okay, thank you, Alison. In regards to duplicate, a lot of different situations may end up having applications more than once, and they are marked duplicate, or erroneously also they can be marked duplicate, that you need to reach out and correct that and find out which application they should pursue and follow. A lot of people, in the wake of filling out an AFR, additional fund request for additional months, they filed a new application, and that is the reason why, main reason, that they are marked duplicate. You want to add something here, Alison? Should I move? Status 17, withdrawn. That is a dangerous one. If you haven't personally withdrawn by calling the call center, please reach out to call center and find out why you are withdrawn, and if there is a chance for putting it back in process. We can also help you with that as well. The statuses 32, 42, and 43 apply for pending application or landlord information. These are honestly need very immediate attention, because it can easily move. If you don't respond to that, you can go to status 19 and immediately to status 14, which is denied.
I would only add that you need to be checking your junk folder to see if your task assignments are going into your junk folder or your spam folder. I get lots of emails from Neighborly Software that end up in my junk folder, even though I have gotten other emails from them that land in my inbox. So you want to be really careful about that. You may get a phone call from a case manager. So if you're screening your calls and you don't respond to calls from people whose numbers you don't recognize, you might miss a task assignment if you said that telephone was your preferred method. And as Raji said, they're assigning very tight deadlines for these task assignments now because they want to clear all these applications by the end of June. That sometimes it's just a day that they want you to get back to them with the document they're requesting. They're also, whenever they put in it seems like they're often asking people if they have requested all of the rent that's applicable. And that has been kind of confusing. But I think that's something they're automatically doing to make sure, because they're processing older applications. Sometimes they didn't request through March. And since you can't submit an AFR now, they are checking to make sure that you're getting as much as you need to cover through the end of March. And you'll need a new ledger to show that you owe that money. So very important that you respond to these quickly so that it doesn't go into a non-responsive status and get denied, as they are turning them around very quickly now, which is good news for those of you that have been waiting a long time, but it's bad news if you're not paying attention and missing out on those tasks that need to be completed.
Martin, hello, Martin, has a question. He says, what if a tenant has an application still pending after June 30th? They will wait for that, Martin.
They have committed to processing all applications by the end of June. That is the word that I'm getting from the state, is that is their commitment. We'll see whether they're actually able to do that, whether there will be any, if they don't, if there will be any protections extended. But right now, that is their intention to
wrap it up by June 30th.
Wrap it up by June 30th. Elaine raised her hand. I'm going to see if I can figure out how to unmute Elaine. Allowed to talk. Okay, Elaine, what's your question? You can unmute now, Elaine. Elaine?
Hello. Hello.
Yes. Hi, Elaine.
Hi. My tenant said he was approved a couple of months ago, but we have not seen a check. And so where does he go for help, or where do we find out where the check is?
Yeah, it's interesting. So there's a difference between approved and funded and dispersed. So until it says dispersed, they have not mailed the check. But if it's been a couple of months, that should have happened. I had that happen to a tenant recently. The check had been mailed and never got to him for weeks. So I reached out to the network officer that is our contact with the people who process the applications, and they were able to, they can cancel a check that was mailed and reissue a new one. So Elaine, a couple of questions. Your tenant still lives with you, or
yes,
in your unit?
In the unit, yeah.
Yeah. And did you apply as a landlord?
No, he did. He is Spanish speaking, so there was a lady who was trying to help him.
Yeah.
But
so there's a couple of things that the difference is if a landlord put in their own application, and the system would then invite the tenant to apply, because eligibility is based on tenant income. So they have to participate. And if the tenant, if a tenant applied they would invite the landlord to participate. If the landlord provided their property ownership documentation and their tax information, then the payment would go directly to the landlord. If the landlord did not participate, then the payment goes directly to the tenant, and they only provide checks to tenants. For landlords, they could sign up for automatic deposit. If the landlord did not participate, then if the tenant moves out, they will not provide they won't cover the back rent if the tenant moves out and the landlord did not participate. So if the tenant still lives in the unit and owes you money, there are possibilities. Either the check hasn't been mailed yet, the check got lost in the mail or was stolen, or the tenant got the money and has not paid you yet. They have 15 business days. If they don't pay the landlord the rent that they owe and they use the money for something else, they can be reported to the program, and the landlord then can, of course, take them to small claims court for the rent that they owe. If you want to check to see, the tenant would, since you didn't participate, the tenant would need to ask the state whether they've mailed the check yet. But if you want, if you don't trust the tenant, you could reach out to us and we can contact the state and find out whether or not the check was mailed.
Oh, okay. So do I call you or do I call Ahmad?
Either one.
Oh,
Yeah.
okay. Okay,
Okay.
so I'll call you Monday then.
Okay.
Thank you.
No problem. Allison, we are short for time. Let's go to the next slide. Other statuses that need your application need to be monitored are status 2, 3, 4, 31, and 40, which is the application submitted. For that, they have to, after that status, it has to go to case manager, open a review, and then review in progress, 2, 3, 4, it moves forward. And also utilities under review if the application was only for utilities and is under review, and recertification submitted. We call it recertification, however, it's also called AFR. That means additional fund request. It means that basically, if a tenant has originally applied for 15 months of rent, since they have room for up to 18 months, they can, if they are still under stress, COVID stress or impact, they can request that the application be opened and 3 more months additional fund request. That's what it means, or recertification submitted. Alison, you want to say something about these statuses, or should we move on?
Yeah, so the reason they need monitoring is because that once there's a case manager reviewing your application and your documents, they very well may reach out for additional documentation. So you need to just keep an eye on it. Don't assume that everything is fine. As we said earlier, that once they're assigning tasks, it's important to quickly complete them so that you don't end up in the non-responsive status.
Exactly. And also other statuses that you may encounter is utilities only applications. Those applications have to move forward. Recertification, the previous slide said submitted, now it's under review. That's another status. And I hope all of them go through statuses 11 and 12, approved pending payment or paid. In progress is a very tricky status that is never has never materialized and never submitted. These are applicants who initiated an application and have never pushed the submit button prior to March 31st, 2022. So they are prohibited from progress, and they won't consider those applications. And appeals submitted. When you file an appeal, that is what happens. All in all, you may not see these statuses in your applications, but these are the statuses that we as a local partner network can identify and move to reactivate your application and move it forward. So please, if you have any question, if you need any assistance, reach out to me or Allison. We have other staffs also who speak Spanish. We can refer you to those staff and help you in that regard. Next slide.
So
or
I would
any...
just wanted to let people know that the utilities only applications are handled differently, and you won't see all those other statuses about being under review and so forth. They will check with the utility before they decide the amount to cover, to make to see what you owe as of the end of March. So the other one I was going to mention is the in progress status. I don't believe it shows up anymore. I think your application just kind of disappeared on April 1st. Haha. If you didn't click that submit button at the end of the application submission page, then it unfortunately they will not process those applications.
As the time moves on, these statuses are being skipped, and mostly the statuses that you will see is what's it called? Task assignments in or non-responsive and denied. All the other statuses are being erased from applications so that they all move on to wrap up this event. Alison?
Sure. So we know that some people are still hurting. They haven't recovered from the pandemic. Some people may have borrowed money to pay rent. Some people are just getting back to work or still not working. And since the program, the California COVID-19 rent relief program is going away, it's only covering through March for those who applied on time. There's a big need for other sources of assistance. We're being asked to refer people to CalFresh and other food resources like local food banks, to LIHEAP and YHEAP for utility assistance, Medi-Cal, Covered California, other health programs to help take care of some of those expenses so that you might have other money for rent. Workforce development and employment training programs to help you get another job if you're still unemployed. CalWORKs, TANF, WIC, and other financial assistance programs to help you make ends meet if you are working, but you're not making enough money. WIC, for example, is for women and infants and children, women with infants and children. I know that there's also some help with childcare expenses. If you are an older person or you have a disability, you should try to get SSI or SDI. And those are federal programs that you would need to apply to. All of these programs, it's kind of hard to figure out what you're eligible for and how to apply and what documents you need. So a good place to start is your local homeless prevention program, which is run by the counties, or a local city assistance program. The advantage of the homeless prevention programs is they'll do an assessment. They'll help you figure out what other programs you're eligible for and let you know what documentation you'll need. And they'll also, if you are eligible for any kind of housing assistance or affordable housing, they can put you in the queue for that. And finally, we understand that a lot of people have suffered a lot of stress, anxiety, and depression as a result of the impact of both COVID-19 itself and the resulting financial difficulties created by the pandemic. And if you are seriously depressed, considering suicide, please call 911. And otherwise, if you are finding it hard to take advantage of the programs that are available, or just feeling extreme anxiety and depression, please make sure that you get the mental health assistance that you need. If you can't find the links online for any of these programs that you think might help you, you can contact Project Sentinel and we can try and provide you with the correct links. We don't help with those applications. Some of the clients I've worked with on their state rental assistance application are now asking me to help with these kinds of applications, and we aren't doing that. We had a contract with the state to assist with the ERAP applications, but we can help you figure out the links or phone numbers for these programs if you're having trouble finding them.
The best resource, Allison, is for them, if anything, they should reach out to their city or county or even local governments for assistance. They have lots of different programs running, and they can get assistance.
I forgot to include this, but probably even better than contacting us is to dial 211 or text 211, because they will be able to provide you with contacts with any programs that should help you.